beautiful day once again. It's good to have you on 8 Years Open Conversation, which is a network flagship political platform through which trending political news, events, and stories are discussed with stakeholders. Now, through this conversation, ATN uses political talks about specific issues, party systems, and actors to explore hope and engender positive impact to the society. Today on 8 Years Open Conversation, we'll take off from Bayelsa State. INEC released Silva's name as Guba candidate in November 11 poll.
Still on November 11, we have elections. INEC's promise of glitch-free polls, more propaganda. Huriwa.
All right, in the issue of mere propaganda, November 11 elections still, we are 90% ready for Kogi State Guba poll. Well, this is coming from INEC again.
2023 elections, Labour Party, obedient movement, and now effectively in opposition, coming from Obi.
And still on 2023 elections, we welcome Obi Labour Party in opposition role. That's coming from presidency.
And still on November 11 elections, Atiku direct support.
Support group. Okay, I'll take that. Atiku direct support group to back PDP candidates. Our guest on the show this morning is Barrister Asim Adams. He is a legal practitioner with over 30 years experience. I call him the consumption man. But today, he is here as a socio-political analyst. We'll come back to you after the break.
Representing people. Mr. President, my people are under siege.
I will place economic stability and confidence.
To condemn this act and call for immediate release of this minister in the Temple of God.
Give us access to our money we put in the bank. The POS operator, she said 3,000 naira is 1,000 to collect 3,000 naira. Where are we heading to?
I've always said there are two sets of people on earth, the oppressors and the oppressed. And in between are the cowards and the hypocrites. Which are you?
No matter how tough the challenge, how high the obstacles, we always overcome.
What Nigerians need now is not about the taunting. Who can come and salvage us from where we are?
Representing people. Mr. President, my people are under siege.
I will place economic stability and confidence.
To condemn this act and call for immediate release of this minister in the Temple of God.
Give us access to our money we put in the bank. The POS operator, she said 3,000 naira is 1,000 to collect 3,000 naira. Where are we heading to?
I've always said there are two sets of people on earth, the oppressors and the oppressed. And in between are the cowards and the hypocrites. Which are you?
No matter how tough the challenge, how high the obstacles, we always overcome.
What Nigerians need now is not about the taunting. Who can come and salvage us from where we are?
Welcome to ATN Open. Welcome back to ATN Open Conversation now. Let's begin by getting you to meet the very constitution man himself, Barrister Asim Adams. Welcome to ATN Open Conversation, sir.
Yeah, good morning to you, Vivian. Good morning to you, Bestseller.
You're welcome, sir.
Good morning, Nigerians. Yes.
So, let's go. But now, before we get on with the first story for today, if you need to run and you are having to challenge on, oh, how do I follow up this conversation, AT, Atlantic Television Network got you covered. All you need to do is get on to watch us live on these platforms, Atlantic Television Network.tv, or you can download the app ATN live from the app store if you don't have that already. Or you can also watch us live on YouTube and Facebook, Atlantic Television Network. Now, let's get into Bayelsa State, everyone. It's the names, restates the names of the All Progressive Congress governorship candidate in Bayelsa State, Chief Timi Silva, and his running mate, Mr. Joshua Makaiva, as candidates for the governorship elections in the state. The electoral umpire, in a statement released on Monday night, said the decision was made in compliance with the ruling of the Court of Appeal, which overturned the earlier judgment of Justice Donatus Okorowo of the Federal High Court in Abuja. You recall that Justice Okorowo's ruling had previously nullified Silva's nomination. However, in a recent ruling by a three-member panel of the appellate court in turn, determined that the Federal High Court in Abuja lacked the jurisdiction to hear and rule on the case filed by Demeso Yefa Kolomo. The court then concluded that Kolomo lacked the local standing to challenge Silva's nomination at the as the APC candidate, since he did not participate as an aspirant in the APC's governorship primary. Now, in line with the court ruling, a total of 16 political parties will be fielded candidates in the upcoming off-season election in Bayelsa State this Saturday. Wow. November 11 is almost here. But before we get into the releasing of Silva's name on the ballot by INEC, you know, they had to take it off now. They are saying they're bringing it back because of the court ruling. There's something very particular about the ruling that says Kolomo is not an aspirant, though he's a card-carrying member of the party. Therefore, he's not. He doesn't have the local standing to apply to petition the candidate for not having the requisite not being in position to contest for governorship. The query here that got his name struck off INEC list is that he has been sworn in as a governor twice already. That's the query. We don't know whether he has local standing. That's for you lawyers to know. But our concern as Nigerians is the constitutional, the grand number. The grand norm says you cannot take out of office a third time. But I'd like to bring you to first start from there to dissect this very matter. Let's get to understand what the three-member panel that sat over this that made INEC release his name may be focusing on, aside the local standing.
Thank you very much. You see, the reason why the Court of Appeal had to decide on this instead of the matter like you listed about taking out of office twice or whatever is because of the fact that it is elementary in law that before any court can go into any adjudication of any matter, the court must first of all look if it has jurisdiction, because jurisdiction is the fulcrum on which, you know, adjudication and the powers of courts to adjudicate rest. That is why in our training, the law school were informed that if you have a brief that is coming to your office, you know, you have to examine so many areas. But the key one, first of all, before you have to file your processes, is to check the particular court that has jurisdiction over the matter you are about to file. Because jurisdiction, like I said, is a fulcrum on where the life wire on which the court's authority rests. Without it, anything that is done by the court, no matter how beautifully well crafted the proceedings is, the court's decision will amount to nullity. So that was the reason why the court has to decide first of all about the jurisdiction to entertain this particular matter. The second one is as talking about the local standard under which the applicant, Colum or what we call him, applied. What the court is saying, like Lord Dennis said, that you cannot put something or nothing on something or nothing because it will not stand. You must put something on something for it to stand. But if there's nothing underneath and you put something that will just fall, the law of gravity will take its course. So local standard has to do with, do you have the authority? Do you have that jurisdiction? That is the personal jurisdiction to bring this particular matter. Do you have the legal rights? Let me use that particular word now. To now bring this matter. The court now decided that the applicant does not have, the respondent in this case does not have, that locus. And the locus, as the court said, litany of decided cases in about 3, 4, 5 months backwards now, since last 30 now, Supreme Court has made it very clear, vividly clear, that the blind could even see and the deaf could also hear that Section 29 of 5 of the Electoral Act cannot be wished away. And it's very, very clear. What is that section talking about? I don't know why politicians keep doing that. Maybe they want to test the waters and find out whether the Supreme Court will bend. Nigerians like, cutting corners. This is what that section is saying. 29 sub 5 of the Electoral Act 2022. Many lawyers, many Nigerians, this particular Electoral Act is in everywhere you go, but those who have it, they don't read it. They don't even know what is contained here. This is the law for electoral matters. Any aspirant who participated, are you getting my point? These are the words used specifically by the Supreme Court. Aspirant participated in the primaries of his political party who has reasonable grounds to believe that any information given by his political party's candidate in an affidavit or documents submitted by that candidate in relation to his constitutional requirement contest may file at the Federal High Court. Blah, blah, blah. So what this particular section is saying that for you to challenge eligibility, qualification, etc. of a particular candidate of your party, you must have participated in the primaries as an aspirant in the primaries. For instance, Silva participated in that primaries with some other people. He now defeated them and now got the, to represent APC in Bayelsa. Those who would have gone to court to challenge this is somebody that participated as an aspirant in the party. The primaries that was conducted some months ago, Coloma would have, looked for one of them, push him, sponsor him to court to challenge this. If that person had challenged this, maybe would have had a different result or outcome, as the case may be. So what this particular section is saying is that because you are a card-carrying member of a political party does not mean you will challenge, eligibility, qualification of your candidate, as the case may be. The law might not sound sweet to your ears, but it's the law right now in Nigeria.
All right, let's come to the meat of the matter, that this is the law. We can't contest that. The judges have taken a position on that. But there is a nagging question we have in our mind as Nigerians, and that's the issue of the releasing of Silva, because the court ruling didn't authorize them to release him. Released Silva. It just basically said that the person who had the case before does not have the judge does not have the jurisdiction, and that Colomo does not also have the local standing to file for to challenge Silva because he's not an aspirant, which is clearly taken. However, the board contention here is that as a person who has been sworn in more than twice, that the Constitution no longer allows for a third time. Is this correct?
Well,
what is the position of the Constitution on this?
The Constitution is clear that if you take your oath of office twice, in that particular instance, you've taken your oath of office twice. That is 4 years. That ends your mandate to have your oath of office, sworn into office, and that you cannot do it a third time because the Constitution allows for only 2 tenure. Now, in the Silva case, the argument of Timipre Silva and his lawyers is that there is a difference between when you were sworn in and removed and when you were sworn in again. Now, what happened is that when he first became governor of Bayelsa State, he was sworn in. But the tribunal that sat over the election tribunal that brought Silva into office nullified that particular election that brought Silva into office. And I said that what that particular decision of nullifying Silva's election as governor of Bayelsa State as at that time meant was that it's like there was no Governor Silva before, because the election was massively rigged, etc., and marred with irregularities.
So I have a quick question,
yes,
sir. When he was sworn in then, did he play the role of an executive governor at any point? Some have the position that he was there for about a year or thereabout.
It doesn't matter. Omehia in Rivers State, for instance, you see, Omehia was there for 6 months. The courts came and removed him and brought in an Amechi. You understand? In the annals constitution, legally speaking, in the pantheon of ex-governors of Rivers State, Omehia is not mentioned legally speaking, it's only politically speaking. And that was the reason why you saw what happened that, I think, the dying moments of the Wike administration, where he said, because Wike had to vest, political suasion, and because they were friends, had to vest on Omehia for him to receive retirement benefits as an ex-governor of the state, building has etc. But Wike, through the House of Assembly, had to withdraw those whatever from Omehia. If Omehia had been a valid governor or legally recognized by the Constitution as a governor, Governor Wike cannot do that under the law. So what Silva is trying to explain is that the court even used the word that Silva never became governor at the end of the day.
Okay.
And that is what the mischief there is what this particular Electoral Act 2022 now cured. And you find out that if you go to section 138, it's going to tell you what, to answer that your question directly,
Okay.
it's going to tell you when the election is nullified by the court and notice of appeal against the decision is given within stipulated period of appeal, the elected candidate shall not withstand the contrary decision of the court. The court says your election has been nullified.
Okay.
Notwithstanding the contrary decision of the court, remain in office and enjoy all the benefits that accrue to the office pending determination of the appeal, and shall not be sanctioned for the benefits derived while in office.
Okay, so back to what I was saying.
Yes.
So, in the 1 year or thereabouts while Silva
Yes.
was the governor,
Absolutely.
before his election was nullified, he acted as executive governor of the
Yes,
state.
of course.
Okay, there's an argument here on this particular
Yes.
matter, which says that if he wins the Bayelsa State Saturday, November 11 election, and he goes into office, he's going to spend more than 8 years in office.
No.
No, but you just said that.
No. We are talking about the question you asked was that while in office, did he not perform duties as a governor?
Executive governor.
Good. He was there before the tribunal removed him.
That's correct.
Good,
so
yes.
he was there.
He
so
was
the
there.
argument now is, even if the court allows him to run for this election and he wins as the governor of Bayelsa State, becomes
Yes.
the governor of Bayelsa State, one, he has taken oath of office a third time. 3, that he was going to be spending more than 8 years in office.
No, you didn't get what I'm trying to say. The court said that particular oath of office that Silva took that first time was a nullity. If the court says you score 0, that every activity you did for that 6 months period, both the oath of office you took was a nullity, was a null and void and of no effect. That it is considered that Mr. Silva never became governor of Bayelsa State by virtue of that particular ruling. If Silva had won the appeal, because they didn't go on appeal. If he had gone on appeal and won that particular appeal, even though the lower tribunal has disqualified and nullified his election and said there was no election of Silva as governor of Rivers State, the Bayelsa State, and he now went on appeal. Appeal now says, Silva, you are the real governor of Bayelsa State. Go back to your store, retain your portfolio as case may be. Then the oath of office would have, start counting. But he was a vice president to Yaradua. He now became president. Now he took an oath of office. He now did the remainder of the Yaradua tenure of about 2 years. Then I did another what's it called, 4 years. 2015 to is it 2019 or whatever? No, 20something to 2015, because he was removed from office in 2015. That is one tenure, making it 6 or 7 years. 2 years of Yaradua remainder of his tenure, and 4 years he did from 2011 to 2015. Is that not 6 years or 5 years?
6 years.
Yeah. Now, you find out that when people went to court, when Jonathan was to contest that 2011 election, and said that if Jonathan is allowed to contest this particular election now, if he wins, he's going to spend, instead of 4 years, he's going to spend 6 years or 5 years in office, which is against the constitutional provision
Of 8 years.
of 4 years, of two tenure, 4 years, 4 years. Now, if you allow him to go and contest the 2011 election again, and he wins, he now runs for 4 years, plus the 2 years remainder of a year advance, whatever, he makes it 6 years. That the constitution does not contemplate, issues of this nature. The Supreme Court came out openly and very wide, unambiguously, and said, no, that is not the essence, because he has to get now.
All right, so thank you very much. Actually, you've really dealt, with all of this.
That's why he's a constitutional man.
You've cleared the whole grass, especially.
A lot of lawyers are confused about that, because they are saying that Silva is going to take, if he takes this now, it's going to be the third oath of office. Yeah. That's not what they are contesting.
Yes.
But now
good. But now, the court said you were governor of Bayelsa State. But when we now found out how you became governor, your certificate of return was withdrawn from you and given to the other party, the person that contested the election with you. So your election and the period you spent in the work for 6 months is a nullity. Right. If the law were to be right, you would have even returned all the monies and benefits that you took for that 6 months, because you entered into an illegal contraption. Right. You understand? So Silva is now saying, why will you not say that I have taken 2 oaths of office?
Okay.
It's a judgment of court.
Thank you very much.
Yes.
I've gotten it very clear.
Yes.
The exemption clause here seems to be the nullification matter. So once
that
it's
is it.
Nullity, then that's
and he's going to, even if he goes to Supreme Court, he's going to regret us, because Supreme Court has not set themselves or reversed themselves in that Goodluck, Ebele Jonathan. I think it was even an article that took Jonathan to court in 2011 when he was to contest, that election in 2011 against Atiku and Buhari. So they went to court and said the court should not allow Jonathan to, continue, because if he wins the 2011 election, he's going to be, with 2 years he has done under Yaradua, and the 4 years he's going to do, that's about 6 years. You understand the point? Now, which is an aberration.
Thank you, sir.
Yes.
All right, let's quickly get straight to the next conversation. Human Rights Writers Association of Nigeria says the credibility of the off-cycle elections in Imo, Kogi, and Bayelsa states is at risk of umpire fail, to use IREV and Beavers as promised. Oriwa, in a press statement by its national coordinator, Comrade Emmanuel Onwubiko, in Abuja on Monday, said, "We have watched with unfathomable amazement the attempt by the Independent National Electoral Commission to once more hoodwink Nigerian voters in Kogi, Imo, and Bayelsa states into believing their propaganda that all the glitches experienced during the general elections of February 2023 had been taken care of. We are aware that the Independent National Electoral Commission expressed its readiness to conduct the November 11th governorship election in Bayelsa, Kogi, and Imo states, respectively. INEC Acting Director, Voter Education and Publicity, Mary Nkem, had given assurance that at People's Town Hall on election security in Abuja, Nkem said all the glitches experienced during the general elections earlier in the year had been taken care of. She said INEC has put a lot of plans in place to guarantee early deployment of sensitive materials to polling units, including ad hoc officers camping near polling units a day before the exercise, rather than people moving from the local government headquarters to the various polling units. They are moved closer to the polling units where they are going to work. So I can assure you that, God willing, we will deploy early. Horiwa has, however, dismissed INEC's reassurance as a mere paperweight. Said when it got to the election petition tribunal, INEC argued that it was legally obliged to do so, and the court agreeably conceded to this claim by INEC, which are hence in contrast to the verbal commitment made by INEC before the conduct of the last general election. Brewer said it will be another wonder of the world if the ethically challenged electoral management body can deliver transparent, free and fair poll given the ambivalence of the officials regarding the adoption of the use of technology such as the transmission of election results in the real time, but would rather opt for manual collation, which gives room for manipulations and electoral heists. Okay, this reading actually gets a little bit disturbing because it's been like a serious tussle in a way. INEC is really seemingly trying to prove themselves this time around, but Huriwa is strongly saying that it would take an elephant to actually enter, you know, the space, the eye of a needle, okay, for this to actually become the truth of the matter in the hearts of Nigerians and the masses. So we would like you to actually, you know, have your take on this matter, because this has really lasted beyond the time we should have it rest to rest.
Well, I'm looking at the conduct of the off-cycle, is it off-cycle election they call them? By off-season, by INEC, as the case may be. INEC has a very big burden to, you know, discharge at this point in time. You know, there's this particular saying that says that a promise is a debt. The moment you begin to make promises to people, and some may get, you know, misled, as the case may be. Now, I really doubt. I know why Huriwa is trying to, you know, call on INEC to do the needful, but for me, I scarcely see whether INEC will improve, you know, in its abilities to conduct elections. Now, I say this because of the fact that you can see, as we have seen today, elections are coming up on Saturday, say in about 3-4 days from now. If it does repeat itself, what will INEC do? Will INEC act in accordance with Section 47 sub 3 of the Electoral Act 2022? That is Section 47 sub 3. That says that wherever there are glitches in a polling unit or the polling area, as the case may be, with the electronic devices or BVAS and IRF, it is as the case may be, INEC is bound to reschedule that particular election. Its own results. You know, these are things, and we don't really know if INEC has to be there. But in Kano State, a man who saw a